Harvard Law School, as we're all aware today, is 200 years old. And that gives us all a chance to think about, and even better, to experience some of the most interesting and pressing issues in the law then and now. And in this room, admittedly, this afternoon we'll be thinking about an issue of central and lasting importance that came up 214 years ago, which means, sadly, that the justices, the advocates, and the parties in the first Marbury versus Madison were all denied even the possibility of acquiring the education that all of today's participants and all of you can be proud of. So I hope you indulge me. I want to just take a moment to set the stage for today's proceedings for the case that most famously held that federal judges can determine and decide the constitutionality of congressional statutes. Briefly, the story that was brought to the Marbury versus Madison court is this. In March of 1801, at the very end of the Federalist administration of John Adams, the president made a flurry of appointments. One of those was for William Marbury to be a justice of the peace in Washington, D.C. Marbury's commission to that post was signed by Adams. It was sealed by the then Secretary of State, but it was not delivered by the brother of that secretary to whom it was entrusted. Marbury didn't get it. Thus, this and other commissions were found on the first day of work of the Republican administration of Thomas Jefferson. And his own Secretary of State, James Madison, did not deliver that commission. And so, this being America, Marbury sued. The case was brought as a trial in the first instance in the Supreme Court. And today will be argued as if it were essentially cross motions for summary judgment. The court there recognized three questions. Did Marbury have a legal right to that commission? If so, was there a legal remedy for the deprivation of that right? And if so, was that remedy one of mandamus by the court? And as you may know, the court answered that Marbury did indeed have a right. There was indeed a remedy for that right. But Chief Justice Marshall in 1803 wrote for the court that the Congress had acted unconstitutionally when it enacted a statute giving his court authority to issue such a writ of mandamus, and thereby announced the resonant rule that the court is empowered to refuse to give effect to a statute that cannot be squared with the Constitution. Marbury did not get to become a justice of the peace. And there are many questions about both the case and its prosecution, but today, for our enjoyment and edification, our oralists and the panel are going to focus on the core and enduring aspects of the litigation, the role and the power of the court in our constitutional scheme. Laurence Tribe, 1966, holds the brief for William Marbury. His historical counterpart, Charles Lee, the former Attorney General in the Adams administration, was destined to become the uncle of another Lee, General Robert E. Lee, born just a few years after the argument. Kathleen Sullivan here steps into the role of Levi Lincoln, the Attorney General for the Jefferson administration. But unlike Lincoln, she will actually and most ably argue the case. It is hard for us to imagine today, but Lincoln declined the chance to argue Marbury versus Madison and remained silent. So, a little more background on our advocates who definitely need no introduction, but are going to get a little luminaries in constitutional and appellate law. Larry was born to Russian Jewish refugees in Shanghai about 2 months before the Japanese occupied that city and then bombed Pearl Harbor. His father, who was born near Minsk, had become a U.S. citizen and thus was taken to a prison camp by the Japanese as an enemy alien. Larry came here to the United States with his family, speaking only Russian at the age of 5. After public schools in San Francisco, he entered Harvard at the ripe old age of 16. He graduated with a Summa in math at 20, clerked for Justice Potter Stewart, got tenure here at the law school at 29, became a university professor in 2004, wrote his iconic treatise on the U.S. Constitution. He's currently working on a book about impeachment, which is coming out next spring. He helped to write the constitutions of South Africa, the Marshall Islands, and the Czech Republic. He's been elected to the American Academy of Sciences and the American Philosophical Society, and is most proud of in all these accomplishments of what he has done with his many students, not only his longtime friend and temporary adversary, Kathleen Sullivan, but two of our panelists today, Patricia Millett and Merrick Garland. Many of you saw two other of his students yesterday, probably, John Roberts and Elena Kagan, perhaps also David Barron of the First Circuit, and a slew of other federal judges, academics, luminaries in the law, and many, many, many friends. Kathleen Sullivan began her constitutional career in Larry Tribe's classroom and went on to scale the highest peaks of the legal profession. She has 11 Supreme Court arguments and innumerable appellate and state court arguments to her credit, and is widely recognized as one of the brightest stars in appellate advocacy, which, I should say, has ventured into every manner of constitutional and commercial law. She is the first and still only female named partner at an AmLaw 100 law firm. And prior to her conquest of the courtroom, she made a stellar name for herself in the classroom as a beloved professor here at Harvard, where her grateful students chose her for the first Sachs-Freund Award for teaching excellence. She then went to Stanford, where she became the first woman dean of any of their schools. And she has brought thousands of students to a better understanding of the Constitution, and for the last 20 years has been the principal author of the Gunther Case book on con law. But of all of her achievements, I hold out to you today the fact that when she was here, in this room, she was the victor and best oralist in the Ames moot court competition. Woo! And last, a few words about our distinguished panel. Judge Jane Kelly, she usually sits on the Eighth Circuit Court of Appeals. She was an undergrad at Duke before coming here for law school. She then clerked for Judge Donald Porter in the District of South Dakota, and then Judge David Hansen on the Eighth Circuit. She taught law for a year at the University of Illinois, and then went to become a federal public defender in Cedar Rapids, Iowa, until she was confirmed in 2013 to the court where she began her appellate career. Judge Joseph Greenaway spends his days on the Third Circuit. Before Harvard, he went to Columbia as an undergrad, and after Harvard, he clerked for Judge Vincent Broderick of the Southern District of New York. He spent some years in private practice. Then he became an assistant U.S. attorney in New Jersey, ultimately chief of narcotics. He then went in-house counsel at Johnson & Johnson until 1996, when he was confirmed as a district judge in New Jersey. And from there to the Third Circuit, and he has also served as a professor teaching trial practice and the Supreme Court at Rutgers, Cardozo, and Columbia. Little out of order, Patricia Millett makes her professional home on the D.C. Circuit. She was an undergrad at the University of Illinois at Urbana-Champaign, then she came to Harvard, in private practice at Miller & Chevalier before clerking for Judge Thomas Tang on the Ninth Circuit, and then spent 4 years in the appellate division, the appellate section of the civil division at DOJ, and then more than 10 years as an assistant to the Solicitor General. When she left the government, she became the co-chair of Aiken Gump's Supreme Court practice, and when she was confirmed to the D.C. Circuit in 2013, she had argued 32 cases before the Supreme Court. And last and first is Chief Judge Merrick Garland of the D.C. Circuit, our own modern John Marshall. He graduated first from Harvard College and then from Harvard Law School, clerked for Judge Henry Friendly and on the Second Circuit, and then William Brennan on the Supreme Court. He then did his first tour at the Department of Justice as a special assistant to then Attorney General Benjamin Civiletti. Turned his talents then to Arnold and Porter in D.C., where he did complex commercial and antitrust litigation, and then returned to the government, first as a federal prosecutor in the U.S. Attorney's Office in Washington, and then as Principal Associate Deputy Attorney General in the Department of Justice, where among his notable roles were leading the investigation and prosecution of the Oklahoma City bombing and the Unabomber case. Confirmed to the D.C. Circuit in 1997, he became Chief Judge in 2013. And so with no further ado, I say oyez, oyez to all of you. Enjoy.
All right, in that case, please seated. Come to order. Today we're going to hear the case of Marbury versus Madison, and we will begin with Mr. Lee representing Marbury.
Thank you, Mr. Chief Justice, and may it please the court. In the absence of a court crier, may I say, God save this court and the United States of America.
Mr. Ali, before we get too far, I want to just ask one question, well, a series of questions, sort of to confront the elephant in the room here. So who is it that affixed the Great Seal to Mr. Marbury's commission?
Well, the Great Seal, in this case, was affixed, I think, by yourself.
Yes. And
you were simultaneously Chief Justice and Secretary of State, a dual honor.
And whose good-for-nothing brother failed to deliver it?
Well, I don't know that he was good for nothing, but it was your brother, James Marshall.
And whose third cousin, once removed, is the President of the United States who ordered Mr. Madison not to deliver the commission.
Repeat that, if you would, Mr. Chief Justice. Third brother, once removed.
Whose
I've never been good on family trees.
Third cousin, once removed, is currently the President of the United States.
Oh, well, he is Donald Trump. J. Trump. But I think you mean Thomas Jefferson.
You must be living in the future sometime.
Back to the Future is my
And one more
name.
question.
Mm-hmm.
As they say in the musical, Mr. Lee, who are you? Whose second cousin are you?
Well, I'm your second cousin, but
Yes,
we've also been good friends for a long time.
All right. So that's all leads to the question, shouldn't I recuse myself from this case?
I think not, Your Honor. And quite seriously, I think you should not. It is true that you were to have delivered my client's commission and didn't get around to it. You were very busy. You were, after all, Secretary of State and Chief Justice of the United States. Your brother was also very busy. You entrusted it to him, but I think he had just been appointed to the new federal judicial post that had been created in the Circuit Court for the District of Columbia.
Yes, one of my favorite inferior courts.
It is definitely inferior. One reason that we didn't try to go there, because if we had gone there, we might have had to call your brother as a witness, and then he would have had to recuse himself. But we needn't call you as a witness.
I see, but if you had gone there, we wouldn't have this argument about original jurisdiction.
Then we wouldn't be able to go back to the future, and everything would be ruined. But of course, if you recused yourself, that would also happen.
All right, we'll leave the question of recusal, whether your opponent wants to raise it. You can move on to your argument now.
All right, if I may, Mr. Chief Justice, I want to structure my argument around 3 points, as I imagine you might, that my client is entitled to the commission, that the laws of the United States afford him a remedy for the wrong done when he was denied that commission, and the right remedy is a mandamus from this court. As to the right to his commission, it's very clear that he was grievously injured when this valuable property, a 5-year judgeship in what may not sound very good, it's also an inferior court, but that 5-year judgeship meant the world to him. He didn't need it, he was wealthy, but he wanted to serve the United States, not just in the Navy, where he is now, but wearing robes of the kind that Your Honor is wearing. His appointment had been made by the President. It had been confirmed by the Senate. The commission had been issued and signed by the President. It had been stamped by Your Honor with the Great Seal of the United States on your last day as Secretary of State, and he therefore is entitled to the commission.
Was delivery of the commission critical to having a claim to the office?
We think that the commission helps because his claim to the office in the way...
Is it critical? Is it critical? Not does it help, is it critical?
In the world as it is now in 1803, we don't quite regard something like a commission as a mere piece of paper evidencing the position. It is the position. Without the commission, he can't put on the robe. So he needs that commission. And it was wrongly withheld by the President and Secretary of State. There was nothing nefarious in the way it didn't get delivered in the first place by the Adams administration. That was innocent error. But it was quite nefarious for Thomas Jefferson and his Secretary of State to go beyond merely criticizing the predecessor administration for what they called packing the courts. They went further. They tried to undo what had been done in terms of a vested right. Now, future presidents might make a similar effort. I imagine in the future, presidents might try to trample all over what their predecessors did. But this court can establish that that is wrong, and it can establish that as a principle for the history of this country.
Well, let's not go to the future at the moment. Let's stay in the present. I like 1803. It's a great place.
I'm happy here, too.
Good. So my question to you then is, you speak of the writ of mandamus and that you want this court to issue the writ. And from whence is this power to come? Where in the Constitution might we look specifically to give you the relief that you seek?
Well, you begin, Your Honor, I think, by looking at the Judiciary Act of 1789, passed by the first Congress. Section 13 of that act makes very clear that this court has the power to, and I read from the language of the statute.
I think the parties have stipulated to the act giving us the power to grant mandamus in our original jurisdiction. And I think the question my brother asks is where in the Constitution is the provision that allows us to do that?
I think Article 3 does it. Section 2 of Article 3 says that the judicial power shall extend to all cases in law and equity arising under this Constitution or the laws of the United States. Now, this mandamus proceeding is a case in equity because there is no adequate remedy at law. We want specific performance. There's no substitute for this particular job. It's not money.
What about the second section of Article 3, the one that says we only have authority for original jurisdiction in two circumstances, cases involving ambassadors, public ministers, and consuls, and those in which the state is a party?
Well, I hesitate to correct your distinguished honor, but it doesn't use the word only. What it says is that the Supreme Court shall have original jurisdiction in a class of cases, ambassadors, public ministers and consuls, states. In all other cases, it shall have appellate jurisdiction. There are two ways to read that language. One way is to suggest that it creates a ceiling on your jurisdiction. That is, in every other case, you have no original jurisdiction, but only appellate jurisdiction. Some have argued that you have to read it that way to prevent the language from being redundant or nugatory. But in our view, the language establishes a very important principle if you read it as establishing a floor and not a ceiling.
Let me just say, now that we're talking about original jurisdiction, I want to coin a principle of constitutional interpretation, and I'm going to call it originalism. Now, I want to read to you from Hamilton's Federalist number 81, where he stated, the original jurisdiction of the Supreme Court would be confined to two classes of cases and those of a nature rarely to occur. Now, since that Federalist paper was used to get people to ratify the Constitution, and since Hamilton obviously knew what the contemporary meaning, the original meaning was, why isn't that the end of this case?
Well, Your Honor, we think that the text is far more important than either the subjective intentions of people who were as distinguished as Alexander Hamilton, about whom I can imagine a play being performed in New York. Thank you. What's important is that the language carries its own meaning, and it has a structural significance. The only court in the United States of a federal nature that is created by the Constitution is this court. If this court could not hear cases involving ambassadors, public ministers, consuls, and states, no court guaranteed by the Constitution could, because Congress needn't create any of the courts that you rightly call inferior.
What if we disagree with you?
I'm sorry?
What if we disagree with you?
Well, if you disagree with me, then I'm not going to succeed in convincing you that you have original jurisdiction. But I am, I hope, going to urge you, and hopefully successfully, not to reach that issue until you have informed the President that no man is above the law, that this is a government of laws, not men.
You agree, though, that if we don't agree with you, can we strike down the act of Congress, or can't we?
Well, that's not yet established, Your Honor.
Well, I know, but
I do think
it will be established by the end of this argument.
I think
so.
I think you ought to have the power to strike down an act of Congress, subject to this fundamental principle. You should not lightly attribute to Congress, especially to the first Congress of the United States, a deliberate decision to defy the Constitution. If you can read Article 3 to avoid that constitutional question, I imagine someday a principle might be invented, perhaps even more august than originalism, about constitutional avoidance, in which you don't needlessly create a clash with another branch of government.
Let me back up and ask, because embedded in this question is the first three words of Section 2 of Article 3, and that is the judicial power. What is, or what do we look to discern what the judicial power is? And in particular, does it include the authority of unelected and unreviewable justices to declare acts of the coordinate branches of government unconstitutional?
I think it does, Your Honor. I think that the judicial power is the power to resolve actual cases or controversies conformably to the law. And the highest law of the United States clearly is the Constitution. It trumps, to coin a word, it trumps both the power of the president and the power of Congress. But we have no reason here to think
How can
Congress,
that be? How can that be? So you're saying that after, I mean, you would agree that the other two branches are also charged with upholding the Constitution, correct?
Correct.
And
That's
that- so
their
if
duty,
we
but they
have-
may fail in that duty.
Well, if we have, I'm trying to figure out how we figure out who has failed. So if we have both houses of Congress and a president sign a piece of legislation, and then you want 4 justices to disagree, why isn't that a dangerous proposition? Doesn't it put too much
Your Honor,
power in the hands of just a few people, which was why we got rid of that king thing?
Far more dangerous, far more dangerous after the revolution is to give either Parliament or the king, either Congress or the president, who take oaths to the Constitution, but whose primary job is to run the government, to let them have the last word. Now remember, we are not urging you to hold Section 13 of the 1789 Judiciary Act unconstitutional.
We're asking you to face the hard problem. If we do have to do that, you're saying the premise of a written Constitution is that the courts can overturn. Is that right?
That's right. It has
Well,
no
so
meaning otherwise.
Let me just ask this. So I'm an old litigator, and the old litigator's prayer is, Lord, let my opponent have written a book. You are no Publius, but I have learned that you have written a treatise under the pseudonym Tribe, wherein you wrote the following: the premise of a written Constitution would not be deserved if Congress itself just judged the constitutionality of its enactments, and courts simply treated the legislative interpretation as definitive. Exactly the point that my fellow justice just made.
And I made the point in the next page. or at least the person you're quoting made the point that even though the purpose of writtenness might not be deserved, the purposes of the rule of law would be. And in that section of the treatise, I think this Tribe fellow said 2.5 cheers for judicial review. That is, he thought it was a difficult question, who should have the last word. But I think throughout his career, he supposedly concluded that judicial review made sense. And I still think it does.
And how do we apply it? How do we do this? You're saying that this is the role of the court. As I hear your argument, is there some kind of deference that we give, call it what you may, to the legislative branch in their assessment of what statute may be, in their minds, constitutional?
On this fundamental question of law, the only deference I think you owe is to avoid gratuitously ascribing an unconstitutional purpose to a law that could be read to make it constitutional. But if Congress leaves no doubt that it means to confer a jurisdiction, that this court concludes that it would be unconstitutional for it to assume, then the duty of this court is to follow the higher law and not the inferior law. And that would mean, if you conclude that Congress clearly violated Article 3, the only choices you have are to follow the act of Congress, notwithstanding your oaths to the Constitution.
Well, that would mean your client loses. So my question here is this malpractice or is this a setup? Was this whole case just a setup?
I don't think so, Your Honor, because if you were to rule that Thomas Jefferson and Secretary Madison violated my client's rights, but that you are without power as the Supreme Court because of the limited original jurisdiction to vindicate those rights, you write an opinion, we take that opinion to the inferior court, the Court of Appeals for the District of Columbia. It's res judicata. It has
I'm
no
sorry,
problem.
if we don't have jurisdiction, you think our decision is res judicata? Is that what
I
you're
think
saying?
is at least highly persuasive authority, and I think your brother would recognize that.
Here's what I'm worried about, and that is not only the unreviewability of these unelected justices, but imagine we were to come to a time in which the court was closely and persistently divided, and there was really just one justice who kept making the dispositive judgments about constitutionality, that you would say are unreviewed, and that one person would have the authority.
I can't imagine that ever happening, Your Honor.
To veto the judgments of the Congress and the president together. Wouldn't that person effectively be king or queen?
I think, Your Honor, first, that's quite hypothetical. But second,
go with the hypothetical.
I'll go with it. It seems to me that in an odd-numbered set of justices, and this court from time to time, as now, has only 6. 2 of them, I see, didn't think this important enough to be here, or maybe they're riding circuit. But when there are an odd number of justices, it's inevitable that some of the hardest questions will be 5-4, just as some of the decisions made by Congress will be decided by the vice president breaking a tie.
But wouldn't that
and it seems to me...
Wouldn't that mean, then, it isn't a clear case if the justices of this court cannot agree, and we are 4-2 or 5-1? How can that be a clear case that the legislative...
That's a paradox in all of the law. There are sometimes close but clear questions. Their closeness is evidenced by the closeness of the vote. People can be quite convinced on both sides, and in that circumstance, we really have no choice but to follow the majority.
Last time I checked, we control neither guns nor money.
Right. In fact, Alexander Hamilton made it a point to say that because you have neither force nor the purse.
So now you're willing to go with Alexander Hamilton.
I like him most of the time.
Before, it was the text only.
Well, let me get back to what...
This is not... I'm sorry, but this is not about the meaning of the text. It's about the philosophy about how we should understand it. And we should understand this court to be, shall we say, the least dangerous branch.
But you're trying to make us much more dangerous, and what I'm worried about is we could issue controversial decision at some point, and some president might say something like, it's Mr. Marshall's decision, let him enforce it.
That might happen. In fact, I could easily imagine a populist president making that very statement. That would be unfortunate, but in the end, the very fact that this court...
Unfortunate, that could be the end of the judicial branch.
I think if you develop the kind of prestige and legitimacy that I am confident the Chief Justice will contrive to do in his
Right now we're working out of this basement of the Capitol. We're living in a hotel.
I don't think you need
We've had the governor of New York say, I don't want to be chief, so it gets turned over.
That's how I got it. But
and he's riddled with conflicts of interest. What prestige are we going to get?
I honestly think, though, that the fact you are actually protected by the fact that you need other branches to effectuate your will. You may need Congress to appropriate money. You may need the executive branch and the Marshal Service to enforce your judgments.
But isn't
what
that
you
the
do
question?
have is...
You're going to name the service after me? I like it.
They have...
But isn't that the
the
crux of the problem? That we'll bring on the ire of the people because we are supplanting our view for the view of the elected officials,
Well,
both the
I
presidency
predict,
and
Your
the
Honor,
Congress?
I predict that if you handle it with the great diplomacy and tact that I think you can, you will accumulate a degree of legitimacy because you have no skin in the game. That is, every other branch is either serving its own interest or the interest of a mob or the interest of a majority.
But what you want us to say is that Secretary Madison made a mistake. And I'm a little concerned about Secretary Madison because as a result of this, I understand he has some reputation as a writer, but he might not have any future after this. If we indeed say, you know, poor judgment exercised in pure conflict with the law.
It wasn't just poor judgment. I think Secretary Madison carried out an unconstitutional directive from President Jefferson. And I think that with the courage that this court, I hope, has, you will be able to tell him that. And I think that the people will, in the end, respect you for standing up to principle. After all, in the Federalist Papers, not only did they say you have neither the power of the sword nor the power of the purse, they said you have the power of reasoned judgment. Unlike the other branches,
You have no power of reason or judgment.
I think I do want to reserve some time for rebuttal, but let me just, if I might, close by saying that unlike the other branches, I hope you develop a tradition of writing opinions, maybe concurring and dissenting opinions, although in your early years you might strive for unanimity. And the very fact of deliberative dialogue within this tribunal will earn it the respect of history. Thank you.
Thank you.
General Lincoln.
Mr. Chief Justice, and may it please the court. My name is Levi Lincoln, Attorney General of the United States, and I'm appearing here for the Secretary of State, James Madison. My learned colleague, Mr. Lee, has urged you to avoid the serious constitutional question here, and I'll say in advance, it is a question that is interesting to the United States, but not of an intricacy proportioned to its interest.
Can I just ask you, as long as we've raised your elephant in the room, and by that I do not mean the mascot that your new Republican Party may one day adopt. The question was raised, if we issue the writ, will your client obey it? Or will your client say something along the lines of that my colleague suggested? Mr. Marshall, enforce it yourself.
Your Honor, that is the first reason why you could avoid the
Yes, but what is the
constitutional
answer?
question in the case.
We'd like to know whether Mr. Madison and Mr. Jefferson are going to abide by the law or not.
My client and the President of the United States owe allegiance first to the Constitution. And if you issue such an order without authority, then you will be acting in violation of the Constitution, and they would be violating their oaths of office if they were to enforce it.
So
So
your
there
answer
is-
is-
Who would interpret it in place of us? If we say it is constitutional, who is it that would say it's not?
Your Honor, my learned friend has suggested that all members of the federal government swear an oath of allegiance to the Constitution. It may be in the future that President Jefferson might pardon some of the unjustly accused and convicted Federalist Republicans under the Federalist iniquitous Alien and Sedition Acts. And when he does so under the First Amendment, he's interpreting the Constitution.
But isn't that too late? Isn't that too late for the folks who have been indicted and sentenced on the Alien Sedition Act? Don't we have to move more quickly to make sure that unconstitutional acts aren't running amok?
I agree completely, Your Honor, and that's why you should today strike down as unconstitutional the apparent extension of authority in Section 13 of the 1789 Judiciary Act to allow you to decide this case. But I think, let me tell you two reasons why you don't need to get there if you want to avoid the showdown of my client and the President
Just to be
refusing
clear,
obey your order.
you want us to strike that down.
If you get there.
Yes, but you wouldn't want us to say more broadly that somebody convicted for insulting President Adams under the Sedition Act was unconstitutionally convicted. You wouldn't want us to do that, or you would?
Would, absolutely. We just didn't get there yet.
Okay.
So, Your Honor, if I could go back to how you can avoid the constitutional question that is raised here. If we get there, then you must strike down the
So
act.
you're in agreement with your client, with your opposing counsel?
Yes, I was surprised that he agreed that we should strike down the act if we get there. But here's
Okay.
how I can save you from this constitutional clash. The first way is you could decide this case is non-justiciable. It's not a legal question. It's a political question.
Well, how do we know the difference between those two?
Do we know it when we see it?
Well, it's a peculiarly irksome and delicate task to
Yes,
tell
it is.
a member
Yes, it
of the
is.
coordinate branch that he must obey an order of the court. How would you like it if President Jefferson or Secretary of State Madison told you whom to appoint as your law clerks or your bailiffs?
I'm afraid we don't have any law clerks yet. We're open to applications, but that has not.
Apparently, we have no crier, as you saw before.
Your Honor, some questions are simply irreducibly and unreviewably granted to the political branches. What if a decade from now our founding...
Which ones?
The political questions.
Which are?
The political questions.
How do we know this is a political question? How do we know this? Is this a political question?
Your Honor, there is no basis in the Constitution for what Mr. Marbury asked. And let me tell you why you could avoid the question.
Wait, for what
Mr. Marbury is
specifically what he
asking
asked?
you for an equitable... He claims a right in equity. What he's really asking for is an interference by the court in the political prerogative of one administration to decide the most intimate thing an administration can decide, which officers it shall appoint. Now, as to why Mr. Marbury does not deserve his commission, he's asking for it under equity. He's asking it, in a sense, under common law. But did you hear my learned friend cite any precedent from Blackstone to Cook saying that a commission is property when it has been signed and sealed but not delivered? No, there is no such authority.
It sounds like a good song, though.
Exactly, Your Honor. And in fact, in the words of the great poet, Stephen Wonder,
That's the one I had in mind, yeah.
Signed, sealed, delivered, I'm yours. But, Mr. Marbury, signed, sealed, and not delivered, not yours. So, Your Honor, if in truth, you could decide this case and never write a great opinion at all by simply saying Marbury has no common law or equitable right to his commission because it wasn't delivered, which is an essential and irreducible requirement for a property right here.
I don't understand your argument about political question. When your party became in control of both the executive branch and the legislative branch, the first thing it did was change the circuit courts, abolished them. The next thing it did, maybe in the same act actually, is made us all go out and ride on the circuits, which we do not like, by the way. Now, is that a political question? Also not for us to consider?
Well, Your Honor, the Constitution authorizes the Congress to do that. The only thing the Constitution creates, as my learned friend said, is you. It does not, it's up to Congress to create the inferior courts. So Congress can create and Congress can abolish.
And your view is that also that we have a very limited original jurisdiction.
I do, Your Honor. And let's turn to that now, because if you do reach the constitutional question, then, as I said, it's an easy case for you to rule for my client, Secretary Madison. Let's look at the Constitution at Article 3, Section 2, and see there, again, what it says. It extends the original jurisdiction of the United States Supreme Court to cases affecting ambassadors, other public ministers and consuls, and those in which the state shall be a party. Well, last time I looked,
What's a public minister and counsel?
it's not Mr. Marbury.
He says he is.
Your Honor, no, he doesn't. He didn't make that argument here. Public ministers and consuls is a term of art under the law of nations for those who represent governments abroad. It is not a term for any petty officer.
You want
in the
us to
United
look at
States.
foreign law?
Your Honor, it's a list. It's
Is that a
enumerate-
yes?
Uh,
In interpreting our Constitution?
Your Honor, if it's useful to my side, yes. So let me just go back to the nature of this list. It's an enumerated list. And expressio unius exclusio alterius est. Or...
More foreign words, yeah.
Just Latin is a useful foreign language for this purpose. Or you might have said, since it lists three in the category, expressio tribus exclusio alterius est. But the point is...
I don't think that's how they pronounce it.
But the point is, Your Honor, that sometimes the expression of an affirmative list is also something that negatives other objects, or it says that that was the list and it was exclusive. Now, don't take it from me. Take it from my client. He wrote the Constitution, and he knew that when you make a list and you enumerate a certain set of cases in which original jurisdiction extends,
now that we're
it
back-
excludes other cases.
So back to your client, are we to not have any notion of constitutional interpretation? It's just look at the beautiful words as he wrote them and that's it?
No, Your Honor. There are lots more reasons why you should interpret this list as exclusive. The Constitution was a grant of limited power. If it weren't a grant of limited power to the federal government, in which the words of the Constitution had exclusive meaning, they weren't open-ended, as my learned friends suggest, they're just open-ended suggestions. That's not what they are. They're a grant of power, limited power, to a federal government. How else do you think my client and John Jay and Alexander Hamilton could have possibly convinced the states to ratify the Constitution?
Well, did the first Congress, which was held under the Constitution and consisted of many of the framers of the Constitution, not know this? Shouldn't we give some credit for understanding of the contemporaneous understanding of the Constitution to the first Congress?
Yes, Your Honor, and I'll suggest I've given you 2 escape hatches here, and I'd be happy to give you a third to avoid the constitutional question. You could hold it a
can
political...
dance, my goodness.
I've already given you could hold it a political question. I've already said to you there's no common law right because the commission wasn't delivered. And third, you could interpret the statute, giving weight to the framers' generation who wrote the statute, and just interpret the statute to avoid the constitutional question. Hold that it granted the power to grant writs of mandamus apposite to an otherwise existing grant of original or appellate jurisdiction. But there is no case to which the mandamus power is legitimately apposite here. This certainly isn't an appeal.
Yet again, varying from the stipulation that was filed with this court as to the understanding of both parties about the meaning of the statute. But
Well,
it's
Your
all right
Honor,
because
you asked the question. I was just trying to adapt. So, if you wanted to avoid the constitutional question and ascribe a constitutional intention to the legislature, then you could just say the writ of mandamus here should be construed as required to be apposite to an otherwise existing grant of jurisdiction. Absent such jurisdiction here, the case must be dismissed. But don't do that because it will deprive you of a wonderful opportunity to write a great constitutional opinion. And when you write it, I think what we've established so far is that the Constitution, to take my learned friend's word, trumps the statute. The Constitution says original jurisdiction does not extend to all cases in equity like this one. It extends only to cases that you don't have before you, ambassadors, consuls in the sense of foreign representatives, and states. And if that's so, the real question is, do you, as the court, have the power to pronounce that the act of Congress in purporting to extend this unconstitutional original jurisdiction is void? Well, at the framing, or at the time, my understanding is there was talk about having a council of revision that would consist of, I think, a mix of executive and judicial officials. That they would be the last word on constitutionality, and that was rejected. Rejected, Your Honor. Exactly. And so, under what theory could it be that by rejecting that they wanted no elected officials involved in this decision, and that would just rest in the hands of a small number of unelected members of the judicial branch? Well, Your Honor, I agree with you that the Constitution contains no provision for this awesome power of judicial review, and that there was time in the framing when other bodies like the Council of Revision were considered and rejected. But Madison should still win the case, and that is because, and you should still invalidate the law, and that is because of the nature of the written Constitution here. You should look not just to the text, but to the nature of the written Constitution here.
Are you like some living Constitution thing?
Just the one you have right now. And I don't want to look to the future or its evolution. I want to look to what this nation did when they wrote it and ratified it.
And when they wrote and ratified it, there are parts of the Constitution where that have protections, right? The executive can veto, the executive can refuse to enforce a law that it deems unconstitutional. Certainly the legislative branch does a lot of, they're supposed to do a lot of back and forth before they come to some agreement on an act to make sure it's constitutional. Those are built into the Constitution. Where's our role in the Constitution?
Your Honor, your role is to exercise reason, precisely because you lack the power of sword or purse, and your role as a co-equal branch is to make sure that you stay true to the Constitution and that you, when the other branches have deviated, step in to set the record straight. Now, you swear...
On what basis can we trust that the people of the United States will pay any attention to our reasoning at all, especially if we use Latin phrases?
Your Honor, I want to speak to this idea that there's anything undemocratic or unaccountable if you enforce the Constitution. With respect, that is just not the case. You are speaking for the people who engaged in a great exertion not lightly to be had when they wrote and ratified the Constitution. And when they wrote and ratified the Constitution, the people said that future members of the executive and legislative branches will be merely temporary, transitory caretakers of trust and agency that they repose in them.
So just to be clear with all those beautiful words, you're saying we should be able to strike down violations of the Constitution. Is that
yes,
right?
Your Honor.
Including ones that President Jefferson supports.
Yes, Your Honor. Yes.
So, and including the ones that the Republican Congress just passed, with respect, for example, why is it that we didn't sit last year?
Well, Your Honor, again, it's constitutional for Congress to control the...
But if we think it's unconstitutional,
then you should act, Your Honor.
then we should strike it down.
I actually don't think you'll need to strike down any acts of Congress for about 60 more years. But if you found one that was truly constitutional, you do have this power. And I want to say again why it's not undemocratic.
Well, pause on one thing. You think the Sedition Act was unconstitutional, don't you?
Well, Your Honor, yes, our administration does believe
Under the
that.
First Amendment,
We
right?
do, Your Honor.
So we should have been able to strike that down.
Yes, Your Honor. Congress shall make no law abridging the freedom of speech. And yes, we do believe that's unconstitutional. But the point I'm making there, Your Honor, is we're not arguing here that this court should take upon itself the exclusive power to interpret the Constitution. We're not suggesting that you are a council of revision supreme above the other
Well, but here's
agencies
what I'm
of
worried
government.
about is, there's a lot of constitutional arguments that could be made. For example, someone might challenge the rules even of this court that don't let women practice before it as a violation of the Due Process Clause. And what if we were to do something so crazy as to say that women could be lawyers and expect the public to follow?
Well, Your Honor, I do think that one great salutary effect of His Honor's acquaintance with President Adams was his acquaintance with Mrs. Adams, Abigail Adams, who said, "Remember the ladies." And I'm certainly grateful that you remembered all the ladies permitted to speak today. But I want to say that when you do strike something down, you must have constitutional basis for it. And since the Due Process Clause of the Fifth Amendment has not yet been interpreted to extend equal protection...
Well, whose job is it to decide whether equal... Okay, so...
Yours, Your Honor. Let me just go back to the point I want to make. I agree with the Justice that all the branches of government are bound by the Constitution. You swear an oath, so do they. But nothing in my argument suggests that the other branches would be forbidden from making their own constitutional judgments. What if in the future we didn't just vulcanize iron, but we tempered steel and we made munitions in great factories, and a war was at stake, and the president seized the steel mills? Could it be possible that this court would not have the power to stop the president from so unconstitutional
You think we
an
should
action?
intervene in war? We're supposed to do that too? Your Honor, if it's an unconstitutional action and the president's polls are very low, then it would be appropriate for you to enter into that.
So what is the constraint on our power? How should we view that? Because it seems, by what you're suggesting, that we can exercise our power in any way that we deem is consonant with the Constitution.
No, Your Honor, not anyway. What you do is you interpret the text and purpose and structure of the Constitution.
Using those Latin words you just used before. But so imagine that a president of the United States, say, wanted to purchase the Louisiana Territory. There's nothing in the Constitution that gives the President of the United States the authority to do that. Are you saying, and this could be very helpful for us to know, that we can strike down the president's action in buying the Louisiana Territory?
If a president were to do that without constitutional authority, and if my client were no longer serving at the pleasure of that president at that time, then it would be fine.
Okay.
Your Honor,
But we got to have remedies, so we just say, give it back? I mean, what kind of remedies do we have here?
Look, Your Honor, what you count on when you pronounce what the Constitution means is the fact that the other branches have also sworn an oath to uphold the Constitution. They owe a line of allegiance to the people.
Do you think President Adams was acting consistently with the Constitution?
When he...
Well, when he had Jeffersonian, I hate to get back to the Sedition Act, but you're assuming that all presidents will be like your president. There may be presidents who are not like that.
Well, that would be a wonderful thing, Your Honor. But what I am suggesting is, yes, what's sauce for the goose is sauce for the gander. I'm arguing that you should strike down this act of Congress if it's interpreted to extend to require Marbury's commission to be delivered. And if you set that precedent, then you may strike down the actions of a president of my party just as much of, with respect, sir,
What about
yours.
of the states? Do we also have the same authority over actions of the states?
Yes, Your Honor. Imagine that there were some day in the future when we were to fight a civil war and the people were to adopt an amendment declaring the right of equality for all citizens regardless of race, and a governor were to stand astride a schoolhouse and bar the entrance of African-American school children. It would be your duty to announce that the supreme law of the land is one that guards their equality. Yes, it would.
Would we have to rely on the sword of the executive branch to enforce that? Are we still dependent upon the other branches to make sure that our wise ruling is actually carried out?
Yes, you are, Your Honor. And that is why the genius of the Constitution places constitutional responsibility.
How can that be, though? There was the whole reason that the Article 3 itself did not create inferior courts was a concern by the states that courts would be created that would be superior to their court system. And so I don't understand on what, it seems to me you're just redoing the entire constitutional balance with your argument.
Well, Your Honor, you asked where does this power of judicial review come from? It comes from the state constitutions in part. We have a tradition going back a century in our nation of courts striking down actions that exceed the power of the delegated political branches, even within the states.
So are we adopting the same approach that the states have used historically? I mean, what is your view on what this judicial review looks like? Is there a deference? Are we to look at this just from our own perspective? How do we do this when we've got two other branches who, as you say, have taken an oath to the very same Constitution?
Yes, Your Honor. You listen with care and modesty and doubt. You listen with skepticism, and you take into account the views of the other branches. And it's not something to be done lightly. That's why I gave you escape hatches like deciding that the commission didn't really belong to Marbury.
Can we
in the
have
first
like a
place.
three-part test or something that you could give us, that we could easily apply?
You should strike down an act of Congress where it is clear to you, based on the text, that it is an unconstitutional
Does clear
action
mean
as here.
unanimous decision of the court?
No, Your Honor. Obviously, there will be differences, and differences are part of democratic debate. But, Your Honor, when an action is unconstitutional, whether it's undertaken by the federal government or the state governments in the future, you are the only branch who can ultimately decide what the Constitution is in a way that isn't infected by short-term politics. Article 3 gives you life tenure, and they can't reduce your salary. I recognize it's not very high to begin with, but the reason why you're given that special protection from the political process is that you, unlike the short-term political actors in our system, have...
Does that mean President Jefferson is only going to take 2 terms?
Your Honor,
I don't believe that's in the Constitution, is it?
it's not
but
yet, Your Honor. It's coming.
It sounds like what you're suggesting is that we should think of ourselves as the protector of freedom. We're going to be here for life. We're hoping it's a long life, and that we actually know better about the application of the law and the Constitution.
I do believe that, Your Honor, not because you're superior...
Is this being recorded? Is that something in the future? I don't...
Not because you're a superior branch, you're a co-equal branch, but you are the one branch that is protected from the slings and arrows and vicissitudes
No, but if we
of
have
political
final,
life.
there's nothing co-equal about final say. That's not co-equal. We have the final word is not co-equal.
Your Honor, you have no other power of sword or purse. You are the weakest branch. And if you don't agree with me today,
Not
you'll
if we
always
have
be
the final
weakest
word.
branch.
If we have the final word to veto the judgment of the representatives of the people in Congress and the presidency, we are the most dangerous branch, are we
Not at all, Your Honor.
And we're unremovable.
Your Honor, I have no doubt that in the future you will become the envy of the world, and judges in foreign countries will say that they envy your ability
Not
to
at
have your
this
decrees
salary.
obeyed.
Not at this salary.
But the reason I think that is so, Your Honor, is you will exercise this power of judicial review wisely and judiciously. The other branches have many powers to try to restrain you. If they don't, they can try to pack the court. They can try to reduce...
Well, you told me at the beginning, or perhaps you were unwilling to answer the question, will you follow our order? You've just given us a very bold argument about why it is so important that we exercise our independence, that we declare unconstitutional things unconstitutional, and where they're not unconstitutional, we enforce them. So I'll go back to the question I began with. If we are to issue the order, the writ of mandamus, will your client obey it?
Your Honor, I would have to consult my client on that.
We'll take that as a no.
No, but your very hesitance is exactly the problem. It shows that there's no commitment on the other branches to adhere to our judgments, doesn't it?
Well, Your Honor...
It shouldn't be an issue under your theory.
Yeah. Your Honor, there's no constitutional basis for you to issue that order. And I think for the President to obey an order of a court that has no authority to issue it would get you off to a very bad start in our nation.
I'm confused. You just said we had all these powers, all this authority. I thought it was a straightforward question from my colleague on the bench. If we so ordered, I suppose you're going to say that there's some sort of attorney-client privilege. Does that come about you? But what would your advice, based on your argument today, your advice would have to be you must follow the order of the Supreme Court.
Well, Your Honor, if you issue an order that is itself unconstitutional, right, let's take
Who
a step.
decide? We've said our order is constitutional, and you said we get the last word.
Your Honor, in the future, there may be a president who says, if the president says it, that means it's constitutional.
Really?
Fortunately,
May I quote you to say that's wrong?
yes.
So we're a co-equal branch, and we will decide constitutional questions unless President Jefferson thinks of the Constitution differently and refuses to follow us. That's the theory we're talking about here.
Well, Your Honor, let's go back here. We're talking about a common law right to property here. This is not a constitutional case. It's a case about a commission that hasn't been delivered.
Why does that make a difference under your theory? If you want us to dispose of this case through a ruling of constitutionality, but you only want us to make those rulings when they go one way.
Your Honor, what we ask you to do is to come to the correct view of what the Constitution means. It couldn't be clearer in this case.
We understand, yeah.
It couldn't be clearer in this case. When the Supreme Court errs, then there should be political dialogue. The President has a bully pulpit. The President can talk about whether certain decisions are wrong. The President can try to speak to the people. The President can...
Will there be a Twitter storm if we rule against your client?
Your Honor, let me put it this way. I want very much to promise you that we would obey your order because I believe the fate of the nation rests upon it. But if you issue that order, you will be getting this court off to a very bad start because you will be arrogating unconstitutional authority to yourselves. Nothing could be more dangerous
than for you to take upon yourself authority the Constitution doesn't give you. So say for another day your clashes with the other branches. All you need to do to decide today is that your branch, exercising your oath to adhere to the Constitution, that you will not arrogate power to yourself that the Constitution denies you. So what I'm asking for you to do today...
I thought I heard you earlier with the good for the goose, good for the gander thing. It can't be that we can only exercise this constitutional power to rule in favor of the executive and not against. You would agree that won't work.
Absolutely, Your Honor. I think you should rule as you see fit. I think there's only one way to come out here. The Constitution forbids the extension of original jurisdiction beyond ambassadors, consuls, and states. Marbury is not an ambassador, consul, or a state. Case closed. You should not issue this order. And when you do that, you're not preventing the other branches from having a dialogue with you in the future. You're not preventing the other branches from disagreeing with you in the future and coming up with their own interpretation. And you don't control the outcome of that clash because you don't control the sword or purse.
So instead of originalism, you would call this new principle constitutional avoidance. Is that right?
Well, I think constitutional avoidance, you don't seem to want to avoid the constitutional question here. You seem likely to write a very important
you said
opinion.
we should rest it on the common law, we should decide on property rights.
Well, Your Honor, I'm just doing my job as a lawyer to give you every possible way for my client to win. But if you do reach the constitutional question, then let me suggest to you that you're engaging in an exercise of judicial modesty today that will give you great judicial power in the future. Judicial modesty today, judicial power in the future, and the fate of our nation depends upon you stepping up and taking your role as a co-equal branch of government.
And does that include the inferior courts as well, or is it just us?
The inferior courts as well, Your Honor, because Article 3, of course, extends the judicial power. It is a power. It is a power, and that when Congress extends that power to the other branches...
Are you saying like one trial judge somewhere in this large country could issue an order that enjoins a law for the entire nation?
Yes, Your Honor. That is true.
Where do you get that in the Constitution?
Your Honor, the judicial power extends to all cases or controversies, and Article 6 makes the Constitution the supreme law of the land. Article 6 Supremacy Clause says the Constitution and the laws of the United States are the supreme law of the land.
This seems an awful bold argument for Jeffersonian Republicans to be making.
Your Honor, I understand...
Have you checked with the President about whether this is an acceptable argument?
Your Honor, the President is very concerned that Marbury not get this commission.
So his philosophical views are, shall we say, depend on the situation. Is that what you're saying?
Not at all, Your Honor. And to close, the President fully backs the position we argue to you today. Marbury must not be delivered his commission, because to do so would arrogate to this court unconstitutional power today. It is consistent with Jeffersonian philosophy that you not arrogate to yourself today power you should not have under the Constitution. And if you follow that exercise of modesty today, you will be the envy of the world in the future. You will have a power of judicial review that is the envy of the world. So rule with Madison. Thank you.
Thank you.
You know, I was listening to my learned friend, and I heard not a word, not one word, as to why President Jefferson and Secretary Madison would be doing anything wrong by simply delivering the commission. There's no suggestion. If you order the President and the Secretary to do that, they can say, well, it's a nice order, but I don't need it. I never intended to violate his rights. Here, have your damn commission. Very simple.
We don't swear in this court, I'm sorry.
I'm sorry. I'm sorry. I thought that we had gotten a little beyond that in 1802, but here we are. No, it seems to me that the idea of sort of mounting on the high horse of constitutional principle to deny this little piece of property to a meager job applicant is really quite bizarre. You know, my colleague imagined that someday in the future a president might seize a steel mill without due process of law, and surely the courts would be able to stop him. Is a steel mill a more important piece of property than a job? What about the steel workers? What about the judges?
Were you surprised?
No. So what about the right that the president has to appoint persons to
I was getting to that, Your Honor. I was getting to that. This is not a matter of appointment. If there were a request to this court to tell President Adams or President Jefferson whom to appoint as a judge, that would be a political question, a question of discretion. But once someone has been appointed, signed, sealed, delivered, Stevie Wonder to the contrary notwithstanding, it's clear under the common law of property that that thing is his. Deeds to land don't have to be delivered in order for you to get specific performance.
Is there an overriding federal common law that we should apply, or do we look to the common law of the state?
Well, I don't think
Not
this
yet.
court should leap into the chasm of federal common law quite yet. It's I'm sure you will find it an intellectually stimulating exercise. But this case, as my friend says, is really quite simple. It's not a political question. A political question is one that requires discretion and judgment, like whom to appoint. But delivering a piece of paper that would have been delivered but for your brother's...
What if we do what you... I'm sorry.
It's a new president. It's a new day.
It's a new day, but
it's
you
a new
can't
political
undo the
issue.
past. The moving finger writes...
We can't go in the past?
Well,
No.
the moving
What are we
finger
doing
writes,
here?
and having writ moves on.
Took
Nor
on a
all
phrase.
your piety nor wit shall lure it back to cancel half a line. Nor all your
Is that
tears.
from the Tribe treatise also?
No, actually it's from the Middle East, and I think this court would do well to look at foreign law.
Are you
from
surprised
time
to
time.
learn? Are you surprised to learn that both the Attorney General for Adams and the Attorney General for Jefferson think that we have the power to strike down statutes as unconstitutional?
It is quite remarkable, Your Honor, but when people have learned from one another and spent years working together, they often come to a common view of a straightforward question.
What
And
if we issue your writ and the government doesn't comply, the president doesn't comply?
Well,
What
that would be
happens
very
then?
unfortunate. He might be impeached for defying the courts. Impeachment is in the air. One of you, I think, has been threatened with impeachment. I think defying the rule of law might well be an impeachable offense. And it would be the law. As this court, I think, ought to say, the very essence of civil liberties is that a right deserves a remedy. And my learned colleague's suggestion that there is no basis in the Constitution, thank you, that there's no basis in the Constitution for what we're asking, that's not right. What about the Due Process Clause of the Fifth Amendment? It says that property shall not be taken without due process of law. What kind of due process is it?
I think she, in the words of the recently departed Lord Hugh Hefner, reads the Constitution only for the articles.
Well, I think... Good one, Your Honor. The articles, though, would not be the law but for the Bill of Rights. They had to add that to get ratification by the states.
I remember. I think, are we out of time?
I think we may be. But, Your Honor, I think what's crucial is that the president be brought within the law. And you can do that in any number of ways, and we're sure that you will be wise in your judgment.
All right, we will take a few moments to deliberate. We will be back very soon. Don't leave.
All rise.
You may be seated. I will begin by delivering my opinion in William Marbury versus James Madison, 1 Cranch 137, February 1803. Mr. Madison has, perhaps foolishly, stipulated before his lawyer got here that Section 13 of the Judiciary Act authorizes this court to issue a writ of mandamus to the Secretary of State. He maintains, however, that this court has no power to issue such a mandamus, it being an exercise of original jurisdiction not warranted by the Constitution. We reject this crabbed contention that Congress lacks power to give original jurisdiction to the Supreme Court in cases other than those expressly described in the Constitution. But, as an advisory opinion, even if we were to accept Mr. Madison's argument, we would nevertheless follow Congress's statute. We reject the novel premise that a statute repugnant to the court's notion of the Constitution cannot become the law of the land. That is too extravagant to be maintained. The Judicial Power Department does not have the power to disregard laws enacted by the Legislative Department, for it is emphatically the province and duty of the Legislative Department, not the unelected Judicial Department, to say what the law is. After all, this court was not in the room where it happened, neither at the Constitutional Convention or in Congress Hall. We therefore issue I at least, would therefore issue the writ of mandamus and direct Mr. Madison to deliver to Mr. Marbury his commission as Justice of the Peace. And if they resist, we will not hesitate to remand them to their beloved France. You may be seated. We're not done yet, actually.
I wondered if it was too late to raise the recusal issue.
Well, I think we'll regard that as waiver rather than forfeiture at this point. Now, I have tried the best I could to establish a policy of having the Chief Justice be the only one writing opinions. But I have independent-minded colleagues, and that's not the result. So each of us will, seriatim, gives our views.
Despite the fact that there is no apparent resemblance, I have learned during deliberations that I, too, am a cousin of the Chief. And as such, I have learned that I am bound by his decision. So I, too, join in Chief Justice Marshall's opinion. So I, too, would order that the issue be writ be issued and that the commission be delivered.
Leave it to the women to get it right.
Don't start.
Oh, we're just getting going.
This case is a testament to the need for the development of a body of judicial ethics. It is contrary to any sense of morality for the Chief Justice to have even, and now his cousin, to have even sat on the case. The text of the Constitution is plain as to the division between our original and appellate jurisdiction. We are to enforce the Constitution. We don't need judges legislating from a bench and coming up with crazy novel ideas about expanding our power. And if a Constitution is to mean anything, it must be the ultimate and last word that governs the people. And we, as judges or justices, are the only power under the Constitution, the branch under the Constitution, empowered to make those very difficult and tough judgments of great allegiance to the law. The Constitution is the ultimate law, and to give it effect. And so to enforce the principles supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts as well as other departments are bound by that instrument. And I will add that I think this power of the Supreme Court to declare laws unconstitutional may become very important in the future if perhaps someone named, Ruth Bader Ginsburg were to argue that women should have equal rights under the law, and so that we should be able to practice law and sit on this court, because we're going to need that judgment for law professors to figure out which of these two opinions is the law of the land.
I concur in my sister's opinion, and not surprisingly, dissent from the majority opinion.
It's not a majority, it's 2-2.
Ooh. I'm so used to that. If the Constitution has any meaning, it is a law superior to the acts of Congress, and an act of Congress cannot exceed what the Constitution allows for the legislation to do, to act. And we cannot allow one branch of the government to decide for itself whether or not it can exceed those limited powers within the Constitution. Our advocates have reminded us how weak we are. We are the weak, nerdy branch. And yet, this is where we do have the power. We are independent. Like it or not, we're here for the rest of our lives. And the votes of the people do not affect our opinion. We are the ones that should be making this decision. And I believe that we do have the power to declare an act of Congress unconstitutional.
Well, we will now leave it to a law school, which we understand is being contemplated in Cambridge, Massachusetts, to decide what the effect of a decision of an equally divided court ruling on the original jurisdiction of the Supreme Court, there being no lower court, what the consequence will be. We leave that to history. Court is adjourned.